2018. Director Cox, will you lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Well, we have public comments section open. Any person wishing to discuss any items not listed on the agenda elsewhere may do so at this time. Okay, hearing none, close public comment, and we'll do a roll call.
Dale Cox?
Yes.
John Northrup?
Yes.
Dan Wilkins is absent at the moment. Blake Treason?
Yep.
And President Lewis?
Yes. Okay. Okay, item 3, Professional Achievement Awards and Anniversaries.
Good morning, President and Directors. Just a real quick, have some achievements to talk about, awards, and also anniversaries. So a couple of achievements that we have were Chewy Sarate received his Mechanical Technologist Grade 3 certification, and Patrick Baird received his AWWA Distribution certification. Several safety suggestion awards, and I'll just read the names here, but we have Robert Holmes, Jim Redmond, Scott Fleming, Greg O'Hare, Chewy Sarate, Don Davis, Ryan Schultz, and Patrick Baird, all with several different safety suggestions. And last we have Tobin Fox, who from the I&E department, who had his 1-year anniversary in July of 2018. So thank you to all of you. We appreciate your time.
Thank you. And thank you, staff and employees, for the dedication that you show towards TTSA. The board is greatly appreciative of your efforts. Let's go on. Okay, let's go to okay, let's go on to item 4, labor relations under the Myers-Mills-Brown Act, training. Related directors.
Mr. Joe Wiley will be here presenting a presentation on labor relations under the Myers-Mills-Brown Act. With that, I will hand it over to him.
Thank you,
He will
LaRue.
take questions.
I've met many of you years back. It's been a while since I've been had the pleasure of being up here, but LaRue asked me to come up and do sort of a basic hands-on kind of discussion of the labor relations issues under the Myers-Mills-Brown Act, which is what the agency is covered under. And so I'm delighted to have that opportunity to do that. I do want to start, and I'm happy to take questions as I go through. I'm hoping you will have questions with it. I will note we've got a pending case before PERB, and I won't be able to answer any questions in open session about the pending case or issues that may be related to the pending case with it. But otherwise, I'm very, very happy to take questions that you have as we're going through. A little bit about my background. I have been practicing law for over 40 years now. I have done nothing but labor and employment law for my whole career, representing management during that period of time. I did start my career at PERB, which back in those days was ERB, because it had a more limited jurisdiction with it. And then I went to work for the National Labor Relations Act, National Labor Relations Board, which administers the National Labor Relations Act. I worked there for 2 years in the late 70s in Oakland as a field attorney for the NLRB. Then went into private practice. I've been in private practice now for about 38 years, and most of my practice is representing public agencies. I do represent some private sector, but most of the work that I do is for our public agency clients. The Myers-Mills-Brown Act, which is what you're covered under, is, whoops. I'm not kidding, this is not the next. How do I get to page? There we go, page 1. The Myers-Mills Millis-Brown Act was adopted in 1968 in California. The law before that was called the Winton Act, and it was from 1964. It gave limited rights to public employees in California to unionize, but didn't really require the employer to sit down and talk with the employees. The employees had a right to unionize, but the employer could say, yep, you got a union, that's all good for you, but we don't have to talk to you. So the change in 68 change was the employer, the public agency, has to sit down and talk to the employees. We'll talk more about that. California has adopted a very different approach than other states have adopted with this. So California has a patchwork quilt approach to public sector labor relations. And when I taught for several years, I taught a class at Santa Clara Law School, seminar on public sector labor law. And I always start with the proposition that whenever you hear the words public sector employees in California have the right to, whatever follows is going to be wrong with respect to a large group of public employees in California. And the reason for that is because we have so many different laws in California that have different rights for the employees. So we have the Myers-Millis-Brown Act. It covers cities, counties, and special districts. At one point, and I don't know that this is the current number, but at one point there were about 3,000 cities, counties, and special districts in California. And so that the MMBA covers all of them. The RADA Act, which is the Educational Employer Relations Act, covers school districts. So it covers K through 14. It covers the community college districts. With respect to cities, counties, and special districts, you have to keep in mind, particularly with cities and counties, there are different rights for sworn staff than non-sworn staff. So for example, police officers have the Police Officers' Bill of Rights, firefighters have the Firefighters' Bill of Rights. They're different, so they have different rights. Those rights are different than other city employees' rights with it. In the school districts, you have classified employees and certificated employees. Their rights are different with it. And you have the overlay of the Ed Code, so the educational code in California dictates a lot of employee relations issues for school district staff with it. Again, none of that has any application to you all with it. You don't are covered under the Educational Act. We then have CIRA, which covers the state employees. It has different obligations. There are different requirements with respect to the state and what the state has to do with its employees. There's then another law that is called HERA, which covers UC, CSUC, and Hastings College of the Law. And it has rights that are different than everything else that you have there with it. And my old firm, years back, we represented the regents, the UC regents. And UC, they have 100,000 employees. And so you can imagine the technicalities, the complications that arise with respect to that. Again, very different than most cities, counties, and special districts would have with it. Trial courts. So in California, beginning in 2001, the trial courts, the county trial courts, are a separate employer. They're a little bit like a special district. The judges are essentially the board of directors with it. And there is one act that covers trial court employment. So all the trial court employees except interpreters are covered under what everybody calls the Trial Court Employment Act. And interpreters are covered under the Trial Court Interpreters Act, and they're different. They're different. They're different from each other, and they're different from MMBA, they're different from HERA, they're different from CIRA, they're different from ERA with it. Then you have separate enabling labor relations provisions for virtually all of the transit agencies in California. So BART, for example, in its legislation that created BART, it has its own labor relations rules that are there in the legislation. And unlike most other public agencies in California, special districts, PERB doesn't have jurisdiction over BART. So again, it's a very different, but PERB does have jurisdiction, for example, over Los Angeles's Metropolitan Transportation Authority with it. So California, you just can't read something, you just can't hear it, where somebody says to you, public employees have the right to, boy, you have to stop and say, what kind of public employee are you talking about with this? Because it may or may not be applicable to your agency or your employees with it, because it's really talking about a different statute. There are actually, I think, 14 different ones. I didn't want to list them all. I made my point, I think, with 7 with it. So let's focus in on the Myers-Millis-Brown Act itself. The first part, and one of the important parts, is it's called the representation area of the Act. They have a right to be representation in an appropriate bargaining unit, and that's critical with it. It's not just a right for employees to be represented by a union. It has to be in an appropriate bargaining unit. And the agency has the right, within reason, to determine what is the appropriate unit based upon community of interest of employees among and between the classifications. So we ask ourselves, what does community of interest mean? How does that work? What are we talking about? And so basically, for negotiations to be successful, you typically don't want to have professional employees in the same bargaining unit with O&M employees, because their interests are different. And PERB has long held that professional employees, and in fact the statute recognizes this as well, professional employees have a different community of interest than non-professional employees with it. And so you would typically have, if you're looking at professional employees, they share a community of interest, they would be a bargaining unit. You look at what's the nature of the work, how do people work, and so typically PERB would say you've got a professional bargaining unit, you have an O&M bargaining unit, people that work in operation and maintenance, typically have a community of interest, they work together, they work hand in glove together. Then you have office clerical, and usually the office clerical, although they interact with O&M and they interact with the professionals, they have a separate community of interest with it. And then you may have supervisory or management employees in a separate bargaining unit for it. Under the MMBA, the agency gets the right to set the appropriate bargaining unit, which you all did, some of you literally did, many years ago, when I think in 90 or 91, something like that, when you said these are our bargaining units with. PERB will defer under MMBA to the agency's determination, so long as it's reasonable. And I know I'm using the word reasonable a fair amount, but there's no bright line test. You can't draw a line and say on this side we've got this, on this side we've got that. And PERB looks at it and says, well, basically what they're looking at saying, do you have an O&M unit? Okay, you got an O&M unit. Do you have an office clerical? Okay. You got a professional? Okay. A harder question can come up is to, well, who is really a professional employee and who is not a professional employee? Who belongs in that professional unit? And if they're not in the professional unit, would they go in the O&M unit? Would they go in the supervisory unit? So you have an additional issue of, okay, we create these bargaining units, but what classifications go into a unit with it? And you've got some flexibility. There's not a bright line. There's not a place where you can look up and it says, go over to column 4 and down to row 2, and that'll tell you that this classification goes in this area. It's also true that just because another agency determines that its classification, fill in the blank for the title, is a supervisory classification, that doesn't mean it's a supervisory classification here. Because it's really based on what are their duties. What are the duties that the classification is doing to make it supervisory or not supervisory? And so it's really, there is no one size fits all. Every agency has a slightly different look at it. Every agency has a slightly different approach to how to do it. And generally speaking, PERB will defer to the agency as long as it sort of meets these sort of general guidelines that I've outlined here with it.
But it's the employee that determines that.
I'm sorry, what?
The employer determines.
That's correct. That's correct, John. It's the employer, it's the board of directors through resolution that say, here are our bargaining units, and here are the classifications that go into each bargaining unit. The employees or the union, if the union comes on site, the union can come on and say, we challenge that. We think you're wrong. And they can go to PERB and say, PERB, we want you to look at this because we think it's wrong. PERB looks at it, and generally, again, as long as you have, you haven't mixed up, you don't have office clerical in with operations and maintenance, PERB generally defers to the local agency with respect to how the bargaining units are going to look.
And Joe, that's codified and you said adopted by resolution in a, we have a, I forget, it's the rules or
Right.
something like that.
Agency,
Yeah, yeah.
It's-
Yeah, so typically you would have, either you would have a freestanding, or you could put it into employer-employee relations rules that some agencies have, and then they listed there what the appropriate units are with it. And it can change. An agency grows, classifications change, the duties change, and over years it can change. But basically, you're looking at the same function with it. And you may remember, some of you I know do remember, there was an O&M unit here represented by Local 39 from about 1991 to 95, something like that. And it was again, a basic operation and maintenance unit that Local 39 wanted to represent.
And does the act require that public agencies adopt these rules and define them, or is it?
No, some public agencies never adopt it. And so if you haven't adopted it, the default is PERB gets to tell you
Okay.
what it would be. So you're not actually required, the board, the agency itself can just sit back and say, you know what, we just don't want any part of it. And then the default would be, if the employees wanted to have a union, they would file a petition with PERB, and in the first instance, PERB would then say to you, here's what your bargaining units look like. But if you have adopted it, generally PERB will defer. Not always. Again, it's whether or not PERB thinks you've been reasonable with it, and obviously reason is sometimes in the eye of the beholder with it. As I was mentioning, the PERB board will determine if the employer's union designation is reasonable. It requires, though, that the employee organization has the support of the majority of the employees in the appropriate unit. So the next step, you got your unit set up, the union has to represent a majority of the employees in the bargaining unit. Now, prior to some recent changes, you always had an election to decide that. As a management representative, I always felt that was industrial democracy, and people should have a chance to vote in private whether they want the union or don't want the union. The law changed a few years back to say now, if the union presents authorization cards from 50% plus one, so if you've got 25 employees in a bargaining unit, if they've got 13 of the employees to sign an authorization card saying, I want the union to represent me, you can't require them to have an election with it. So if it's an appropriate unit and they've got those 13 cards, the employer is obligated to represent them. Again, it assumes that the cards are valid. It assumes that the cards have been signed within a 6-month period prior to the time they were presented to the employer. The reason why over all of my years I've been very opposed to it is that a lot of times people sign the cards and they don't do it in private, and they may feel pressured to sign the card. So they're having lunch with their friends, and their friends are saying, here, sign the card, here, sign the card. And sometimes people just, look, I don't want to stand out. It's just easier to sign the card with it. And that's why I always felt you can have an election. And PERB did elections well. They really were secret ballot elections, so that you could feel comfortable, hey, a majority of our employees really do want to have the union. It's not just a question of they signed a card or didn't sign a card.
Joe, maybe a stupid question, but so employees decide they want a union.
Mm-hmm.
do they have to then go to these established IBEW or other union houses, or can employees form their own union within just their own organization?
Blake, that's a great question, and the answer is no. The word is, it has to be a labor organization, but it doesn't have to be IBEW, it doesn't have to be Teamsters, it doesn't have to be SEIU. So we've got clients where it's the Employees Association, so fill in the blank, the name of the agency, East Bay Water District Employees Association.
Okay.
And they've got an employee association of 75 members, and they actually go out and they hire a person who comes in and speaks for them in labor negotiations, but they don't want to be affiliated with a bigger union with it because they feel they're giving up their independence in doing that. So no, it does not have to be. It does have to be a group that they have to have some bylaws. You know, it has to be identifiable, and they have to have as their principal purpose that they're going to be meeting and conferring or negotiating with the employer about wages, hours, and terms and conditions of employment. It can't be like a social group with it. It has to be a group that the whole point is that they want to do labor relations with it.
Joe, who verifies the count as far as the election to the union?
Ultimately, you can have PERB verify it,
Okay.
but there is no very good way to verify it because signatures can be forged. So what the employer can do is the employer can submit the list of names, 25 names. The union submits their cards to PERB or to some other third party. Sometimes you can use I've actually used a minister in the area where everybody says, oh, this person's fair and honest, we'll have him count to be sure that it's a majority. But it's pretty hard to know, is that Fred's signature or not Fred's signature on it? And again, it gets back to me of, I think they ought to have an election with it, but that's not the law, and nobody really cares what I think when it comes down. The law says you can't force them to an election. So there is a way to verify, but it's not a very foolproof way to verify.
So what you're saying, Joe, is that there is really no oversight on if a body of employees want to bring in the union and they start putting out these signature cards or however they're going to do this, there's no oversight committee to oversee this process, correct?
Correct.
Okay, so what is to protect the agency from some kind of fraudulent action within a group of people trying to unionize?
Nothing.
Nothing. Okay, that's the first question. The second question would be, if you have that 50% plus one that you were talking about in these card signature cards,
Mhm.
the 49% that opt out,
Yes.
are they going to be drug in kicking and screaming, or do they have an individual say in whether or not they want to be a participant in this unionization?
Let me back up. So the law is that the union has to represent the bargaining unit. And these, in the example I gave, 12 people would be part of the bargaining unit. And so when the union negotiates, the union would be negotiating for the bargaining unit with it. Until about 2 months ago, they would have had to pay either dues or an amount equal to dues to the union for the union doing this. There was a decision, you may have read about it in late June, called the Janus decision, that said that's unlawful. A union can't require people to financially support the union. And so at this point, the union would have to bargain for all 25, but it doesn't get money from all 25. It only get money from those who voluntarily agree to give it money.
I see. So basically, the 49% that don't choose to be part of the signatures in the card to bring the union forward, they're going to be able to sit back and get the benefit of the unionization without contributing to support the union.
Correct. Correct. And they can, the law is that they can file a decertification petition. After the union has represented employees for a year, if 30% feel that the union is not doing a good job, they can file a decertification petition, and that they can force to an election with it. Yeah.
Is that 30% of the employees who are contributing to the union, or
No,
30%
it's
of
30% of the
targeted?
25. So again, using the example that I gave, it would be 8 people would have to sign a list saying, we the undersigned no longer wish to be represented by Union X. They sign it, they date it, they file it with PERB, and PERB will do an election to determine whether or not to decertify whatever the incumbent union is.
So that would, PERB would do the
They
election?
would do that,
Okay.
yep.
The question with the third-party certification process, whether it's PERB or local elections office or whoever is deemed appropriate, if they wanted to do some kind of a verification on the cards, do they have the ability to do that, or they get a card with a signature on it and they have to assume it's valid? They couldn't like call the employee.
They can't do an investigation. I've had clients that had signatures of the employees, so we ask them to compare the signature. But I don't know about all of you, I often sign my name a little bit differently with it. And it's pretty hard for a non-expert at this to be able to look at it. So pretty much they just go by, it's the signature, it's the person's name, and they count it. That's the reality of how it works.
So one final question for me with this, Joe. So when you have a unionization effort and you have a group of people that are calling for the union and they do these signature cards, if you don't have an oversight committee to monitor or see to it that the signature cards are valid and that the people that are signing these cards are legitimate, then aren't you open for conflict or for the potential of conflict within the group?
Well, yeah, I mean, there are sometimes hard feelings, but the group that doesn't want the union versus the group that does want the union, and there can be hard feelings about that. So that is certainly true. Is that you end up with hard feelings.
A fraction
Yes.
Group of employees.
Yes. Yeah, and where you can have some I don't know, heated arguments, let's say over lunch about it.
It's the list of people who signed the card, assuming there's a petition, cards are sent out, they end up with 50+1% signing it. Is the list of people who signed it a public document?
It is not.
Okay.
It is not. And the reason is that there's the fear of reprisal,
Okay.
the fear of doing it. And frankly, I would say to you, you don't want to know.
Okay.
Because if you've got an employee who otherwise you might be ready to discipline, who may have performance problems, the last thing you want to know is that they have the first person, they've got like the John Hancock on the Constitution, they're the first signature with it. You actually don't want to know.
And sometimes, you gave the example of, the cards being perhaps sent out during a break period or something like that, where someone feels perhaps pressure to sign it. Does a person have the ability to retract their card after they've signed it?
That remains an open question of law. I think that the answer is ultimately yes, they do. But they have to do it in some relatively timely way. So it's not a question of I signed it and 4 months later I decide to retract it. They would need to do it, I would think, within about 30 days to be able to say, no, I did retract it. Within it.
Who would they do that through? Would they do that through the union?
Yeah, they do that to the
Through
union.
PERB?
They do that to the union. They write to the
Okay.
union saying, I don't want to, I'm pulling back my card. And hopefully they'd copy the employer or something with it so that the employer would know that people are pulling back their cards. But they don't have to do that. Let's move on and talk about, so now that the employees are represented, and what's the obligation of the employer under the MMBA? The union has a right to meet and confer with the public agency representatives. And it's always interesting to me in California, we've chosen the phrase meet and confer rather than negotiate. Under the NLRA, private sector, they negotiate. The public sector, apparently, they felt that was a little too blue collar for the public sector, and so we meet and confer. But they mean the same thing. It's negotiations. It's just a different word for it. The scope of it is as wages, hours, and terms and conditions of employment. So it's very broad of what your obligation is to talk with the union about at the bargaining table. But you don't have to consider, for example, what services you're going to provide, how you're going to provide services. That's all outside the scope. So it's wages, it's hours, it's things of how they get paid, how they work, but not what services are we going to provide, how are we going to provide that, what kind of staffing are we going to have. Those are all management prerogatives, and you don't have to negotiate those things. What does it mean to meet and confer in good faith? You have to meet face to face for a reasonable number of times to exchange proposals with an intent to reach an agreement. It's not very complicated. It just really means you come, you sit down, you're face to face, can't be done texting, can't be done via Skype or FaceTime, and there's no set number of times. And for me, typically it'll be anywhere from, depending on the size and complexity, anywhere from 6 to 10 bargaining sessions usually for the negotiations, usually about half a day or 3/4 of a day at a time. And almost always where the rubber meets the road is what pay increase you're going to give me. We talk about a lot of things, but when it really gets right down to it, that's what most people care about, is what's my pay increase, and more recently of my health benefit, because health benefits have become so costly. So those two things, we spend a lot of time talking about exchanging proposals. Yes.
Just taking a step back again, so just the timing, so the employees get 50+1% signatures on the cards. Is that, boom, there's a union, or what is the timing to actually, make that?
Yeah, let's assume they have requested it in an appropriate unit.
Mm-hmm.
And let's assume that they've got the 50% plus 1, the 13 that I was talking about. The employer is obligated by law to recognize them. Assume the employer does that.
How is that done? Is that a board sort of action of recognition?
Board action, we're recognizing you, or you can delegate it to the general manager and have the general manager do that, but there will be a letter to the union saying, we've received your cards, we're recognizing you as the representative in the O&M unit, and then usually within a month, you start meeting and conferring with it. It's pretty typical. Sometimes a little less, sometimes it might be a little more, depending on people's availability, depending on kind of what's going on, but usually within a month after that.
Just on the verification on the cards, it sounds like it's not appropriate for the employer to be the verifying party.
Typically not, although I've had some situations where the union has said, no, we don't mind, have the employer go ahead and do it. Usually that's a situation where of the 25 out of 25 have signed, and so they're not too worried about retaliation, because it's pretty hard to retaliate against everybody in the bargaining unit with it. But typically, no, it would not be that. It would be, again, as I said, I've cautioned clients, you don't want to know who signed, because then it's like when somebody comes in and applies for a job, you don't really want to know that they've got some impairments and things, because if you don't hire them, it can be suggested that the reason you didn't hire them was because of the impairment. And with this is somebody will say, well, yeah, the reason why you gave me a written warning for being late wasn't because I was actually late, but because I had signed up for the union. And it's easier to say, we don't know who signed up for the union. The public employer must provide a reasonable number of employees a reasonable amount of release time for time spent in the meet and confer. So with a bargaining unit of 25, like what I've been talking about, you're usually looking at 2 or 3 employees being released on employer time to do this. I have, over the years, told people, I think this is the biggest difference between public sector and private sector, is subparagraph C there. And the reason is, in the private sector, the employer doesn't pay for the employees to negotiate. They either have to use vacation time, which they often do, or the union pays their wages, or the union makes up. So they'll take time without pay, and the union will make up the difference with it. It makes it a very efficient process in the private sector. In the public sector, it becomes a much less efficient process because there's not a motive to be efficient. I've gotten jaded over the years, and there will always be a few people who say, actually, I'd prefer to be sitting at the bargaining table doing negotiations than doing my job. And so, again, there's not a motive to try to move smartly through and get it done.
Does the agency's rules define what these reasonable number of employees in?
Usually not.
Amount of
It's
time?
it's
Okay.
usually the first bargaining session. And so, a union brings 10 people, and we say, no, we're not doing 10 people out of a unit of 25. And if we had a unit of 500 or 600, maybe 10 people would be reasonable. But usually it's a subject itself for meeting and conferring as to how many people are there going to be. And then the employer always in the negotiations has the ultimate right to implement its wage offer. It's after it completes all of the process. But about 8 or 9 years ago, law changed to require fact finding. And what that means is a neutral third party comes in before you implement and offers an opinion about whether your last best final offer or the union's last best final offer is more reasonable. It's not binding, but you gotta go through, it's a dance that now in the public sector in California you have to go through with it. It's a neutral person who comes in and hears all the evidence and says, I think, and they do it basically, it's a comparison. And so you're saying, we're offering the same pay increase that other local agencies gave, our wages compare favorably to that. The union's saying, no, your wages don't compare favorably, and every other public agency got a 2% higher pay raise than you did. But it requires you to go through this fact-finding, it's non-binding fact-finding process if you're in negotiations.
So what comes out of the fact-finding process?
A report where the fact finder says, I think management's more reasonable in what it's doing, or I think the union's more reasonable in what it's doing. And it's just a report that goes to the board and to the public.
So that's basically where you come to impasse, the agency and the bargaining organization, whether it's a union or an employees association, have gotten to a point where they can't agree on the labor contract.
Exactly.
And then, so the fact finding is a third party that comes in and offers an opinion as to.
A non-binding opinion.
Yeah.
Here's the evidence, and usually, again, as I say, it's a comparator with it. There is ultimately the agency can plead poverty. So yes, we understand we're not offering what our neighbor agencies are offering, but we have no money with it. And that too is there, but usually it's mostly a comparator. So you do a survey of your local agencies to be sure that you're in pretty good stead in terms of what they're doing, what the cost of living is. Our wages are pretty competitive with it. So let's move on and talk about the other big thing with it is.
I have a
Yeah,
follow-up
yeah,
question there, Joe. So, let's say you get to impasse, you go through the fact-finding process, and whoever does the fact-finding, they offer an opinion that what the bargaining unit is requesting is more reasonable, but the agency says, sorry, we're not gonna implement that.
Correct.
Here's what we're offering for pay, here's what we're offering for benefits, that's the deal. Is there an appeal process?
There doesn't need to be because it's not binding. It's not binding, it's just simply this person's opinion about it. It can come back to the board of directors, and the board of directors can say, fine, we understand their opinion, but we don't have the money to do that, for example. We just
Right.
can't do it.
Right.
And so they can then implement their position with it, and that's the end of it.
There's not an ability to appeal, there's just whatever undercurrents may exist in the organization.
Right.
There's employees.
They can go on strike, so the employees can go on strike. They're limited rights to strike. They can't strike if the strike creates an imminent threat to the public health and safety. And in wastewater, there are some arguments to be made that a strike does create an imminent threat to the public's health and safety. But basically, there's no appeal. The public agency board gets the final say as to what they want to do. It's just an intermediate step between the negotiations and the implementation, is having this third party come in and opine about the parties' relative positions. So let's take a few minutes here and talk about the other big part of this, which is the right of employees to be free from interference or discrimination. So we've talked about representation, we've talked about meeting and conferring. The MMBA says that employees have a right to be free from interference and/or discrimination for engaging or not engaging in union activity. And typically you're talking about interfere, intimidate, restrain, coerce, or discriminate with it. And so let's talk for a minute about what's interference. That's usually what's alleged is you interfered with it. It's the easiest thing to prove is there was some interference. A lot harder to prove restraint and coercion. As I say, I've been doing this for a long time. I don't know that in the public sector I've ever had a restraint and coercion case. I don't, you know, restraint is like I grabbed you and I drugged you somewhere. I don't know. It's almost always interfere with. And so what an employer cannot do in California in the public sector is they can't make comments to employees during a time when the union's trying to organize them. That would, for example, say, it will do you no good to have a union here. We hate unions, and you'll get yours if there's a union. You can't, that's not permitted to do. What is discrimination? Discrimination is you took an act, an adverse employment action, because of somebody's union activity. And they've got to prove not that, they've got to prove both. It was an adverse employment action, and it was because of union activity that the employer took that action. Typically, it's termination or some other discipline that they're complaining that they got terminated because of the union activity, or they got suspension because of their union activity. Then also, if the employer refuses to meet and confer in good faith with the majority representative. So that's an unfair practice as well. That violates the law. Assuming we've done everything, the union's been recognized, they want to meet and confer, and you either say we won't, or you do, but you don't do so in good faith. You don't meet a reasonable number of times. You don't meet with a goal towards reaching agreement with it. They can file a charge saying that you refuse to meet and confer in good faith with the majority representative. You can't discipline or threaten employees for participating in union activity. And if there is a recognized bargaining representative, you can't make unilateral changes in terms and conditions of employment without first meeting and conferring with the recognized union. So let's suppose you have a union and you're in negotiations for a new labor agreement, and you decide, you know, we want to change the vacation allotment. And we think we've been too generous with vacations and we're going to cut back. And you do that unilaterally. You can't do that. Maybe you change how people are able to sign up for vacation. That's a more subtle one. So that you've always had everybody, we just do it by seniority, and first come, first serve with respect to seniority. The more senior people get it first with it. Doing those things unilaterally, if you have a recognized employee organization that represents your employees, is against the law. So you've always got to go to the union first, talk to it first. Doesn't mean you can't make those changes, but it means you've got to first talk to the union to see if the union will agree. You don't have to have their agreement, but you do first have to talk to them before you make the change in the term and condition of employment. And that the issue about fact finding, even if you want to change the dress code, you've got to meet and confer with the union about changes in the dress code. And you would have to actually go to fact finding if the union wanted to about your dress code. I don't know how that works. I haven't ever yet had a union asked to do that, but I'm not sure how you compare the dress code at TTSA with the dress code at Tahoe City. I don't, you know, wages I can see how you compare it. It's money, it's easy to compare. I don't know how you compare dress codes, but under the law, you would have to, if the union asked, you'd have to go to fact finding. And then.
What if it is safety gear in
I'm sorry?
apparel? Safety gear in apparel.
Yeah, you can require safety gear,
So
but
that's
you,
legal.
yeah, if it's OSHA required with it, you can require that.
Yeah.
Yeah.
I have a question as it relates to interference in a couple of scenarios. So let's say TTSA has 2 bargaining units. And let's say there's a group of employees in one bargaining unit who are having conversations about whether or not to unionize. So those employees are trying to get opinions from each other and maybe from other parties. So the 2 scenarios, if one of those employees asks an employee in a different bargaining unit, hey, do you think we should unionize or not? And the employee in that other bargaining unit offers an opinion on that, is that considered interference?
No, it's only, and I should have said this, and thanks for raising it, only management or you all can be found to have unlawfully interfered with. So another employee, you and I are coworkers, I can say to you whatever I want about, I think the union's the worst idea in the world, my brother was in a union and it was terrible, they had a strike, he lost his job. Not unlawful at all, because we're coworkers with it. But if I'm your manager, I have limits on what I can say to you.
So if as a manager, an employee approaches you and asks your opinion, your best response is?
The law doesn't allow me to offer you my opinion. And that's an overstatement, I want you to know, because I draw the line farther back. There are opinions that you could offer or not offer. I think you're better off, draw that line back here and don't offer the opinion. They can get it from their brother-in-law, they can get it from their father, they can get it from their coworker.
Bartender.
Huh?
Or a bartender.
Or a bartender, yes, yes. Examples of union conduct, the union threatens employees if they refuse to support the union. That's an unfair labor practice by the union, and people can file charges with PERB. With that, they cannot do that. They cannot threaten people if they won't support the union. They can't discipline union members for filing an unfair practice charge against the union. And this goes to the issue that was asked earlier. They have to represent all employees in the unit fairly, and what's called the duty of fair representation. And at least so far, Janice hasn't impacted that. Somebody may later say, no, those people that don't pay to support the union doesn't have to represent, but at least at this time, they still have to represent everybody equally and fairly. Let's talk now a little bit about enforcement with it. So until 2001, the MMBA was enforced by either side going into court. So if the union thought the employer was engaged in unfair labor practices, they had to go file a petition with the Superior Court and get a court order about it. In 2001, they changed the law and PERB got jurisdiction over MMBA jurisdictions. PERB has 5 members. They're appointed by the governor. Typically, when we have a Republican governor, 3 are management types and 2 are union types. When we have a Democratic governor, 3 are union types and 2 are management types, and that's the way it is right now. So there are 3 members, 2 of whom are former union side attorneys, and 1 of whom is a former union business agent. And then there are 2 that come from the management side, both of whom were attorneys with, well, one was a non-attorney, but he was a consultant with management, and then the other was an attorney represented management with it. They handle representation cases, as we talked about earlier, unit determination, and they handle unfair practice cases. They ultimately go to the board. The board sits in Sacramento and oversees the enforcement of all of those statutes that we were talking about earlier. The PERB board oversees it. So an unfair practice complaint, the union files, I don't use the union because about 19 out of 20 cases are unions filed against employers. The union files what's called an unfair practice charge with, actually in the public sector, they call it an unfair practice charge. In the private sector, we call it an unfair labor practice charge. But somehow, again, we don't, in the public sector, like to use the word labor because it suggests too much dirty hands, and also we just call it an unfair practice. I almost always refer to it as an unfair labor practice because that's what it is it's an unfair labor practice. but the union will file that charge with PERB. PERB doesn't really do much of an investigation with it. The union files a charge, and the charge could say, the employer fired Fred because of his union activity. They'll issue a complaint. You as the employer, does you no good to present evidence that says Fred was absent or late, 35% of the time. You still get a complaint issued against you because it's a prima facie case. The union's alleging it happened for his union activity. There's no dispute that he was fired. And so what PERB says is we'll let an administrative law judge decide. So almost everything, they just say, look, let's set it for hearing, we'll let an administrative law judge decide. And so it's a real low threshold to get a complaint issued by PERB. The hearing then is before an administrative law judge, who is usually, almost always, an attorney, some of whom have backgrounds in labor and employment law, some of whom don't. PERB has right now, I think, about 6 or 7 administrative law judges. Some are in Sacramento, some are in San Francisco, and some are in LA, where they hear cases. They are less formal than a court proceeding would be, but they're still formal. They take evidence, there's a record that's kept, the testimony is under oath, parties file post-hearing briefs with respect to it, and then the administrative law judge issues a decision. But it's just a recommended decision, so it's not binding on anybody. Then they write and they say, yeah, there are 4 allegations, I find 2 there was not factual support for, and I find 2 there was, let's say. And so they issue an order that says, employer, with respect to these 2, you have to cease and desist. Either side can then file, because it's only a recommended decision, they can file an appeal of the recommended decision. It's called exceptions under PERB, to the board itself. So if you lose before the administrative law judge, you get to appeal to the 5-member board. Typically, the timing goes something like this. It typically takes PERB anywhere from 3 to 6 months to decide whether or not to issue a complaint. It takes 3 or 4 months to set the unfair practice hearing. It takes about usually between 90 days and 6 months to get a decision from the administrative law judge after the hearing. If you lose and you file an appeal, you get a month or so to file an appeal to the PERB board, and then it can take anywhere from 6 months to 2 years to get a decision from the PERB board. So most of these things don't happen very quickly. Is that from the time that the original unfair practice charge is filed until you have a decision from the PERB board is often 3 years with it. And even that isn't a final decision. Either side that loses before the PERB board could file an appeal to the Court of Appeal with it. And that takes another anywhere from 9 months to 2 years to get a decision from the Court of Appeal. So again, it's not uncommon for it to take 3 to 5 years. I've got a case right now for a client in Fresno. The act that the employer did that the union complained about happened in 2009. We just, on September 18th, had the hearing before the 5th District Court of Appeal. So 9 years from the time the act occurred until we actually end up before the Court of Appeal with it. That's what I've got with it. I don't know if you've got more questions. Yeah.
Just, let's say a bargaining unit is established there, they get, your example, 25 employees in that bargaining unit, 13 sign the card, so it's validated, they become unit. So then there's a meet and confer to kind of establish the ground rules. So
And I would add, ground rules is exactly what it's called. Is that you have an agreement on what are the ground rules for how we're going to do this.
And so you've got, one of the things you do at that first meeting is determine who's going to be kind of the representative of the union, of that bargaining unit. You've got 13 that signed and 12 that didn't. And let's say that the agency says, well, we want to bargain with 3 people. You've got this split, bargaining unit. Do the ones that, who determines what are the 3 people that are going to be supported there? And as there's meet and confer activities, is there any requirements on the union to meet with all of their representatives to, kind of inform them and solicit input potentially so that the representatives then come to the table with, you know, the full kind of input from everybody within that bargaining unit.
No, the union decides who will be their three people. So let's suppose we all agree it's three people. The union picks who the three people are. The employer doesn't get any say in who the
Okay.
three people are. The union picks them. And if people are not members of the union doesn't have to meet with them at all. So for example, my wife worked for a school district for many years. I always tried to get her to join California Teachers Association so she could go to the meetings and be a participant in it and have a say. Because the CTA wouldn't allow non-members to have any say. And the law allows them, if you're not a member, and the law can't now with Janice, they can't make you be a member, they can't make you pay anything. But if you're not a member, the union doesn't have to even talk to you about it. And so that's one of the reasons to be a member, is to have your voice heard at the union meeting. Raise your hand and say, I don't agree with this approach. Here's the approach I think we ought to have. But the simple answer to your question is, the union decides who they'll meet with and who their bargaining team will be. The 12 wouldn't get any say in that at all.
On the bargaining unit itself, and the determination of who's in the bargaining unit and who's not. And, you know, it's by the bylaws of the agency. And you redo their scope of employment for each and every individual, and you're deciding what, you know, if we're gonna review the scope of the bargaining unit, okay, who's gonna be in and who's gonna be out, okay? We have a 91 or 93, I think it was, is when we adopted, who's in and who's out, okay? Things have changed, okay? Are the employees that feel that they should be in a bargaining unit, but the past bylaws say that they're not, can those employees, they have to go through PERB to get the ruling changed from us?
Yes.
Okay,
Yep.
that's the procedure.
That's the procedure.
Joe, I'm gonna be very specific here. I wanna thank you for being here and helping us out with this, because what I've been through as a board member here has been very uncomfortable at times, and this goes back several months ago, where we had this room full of employees, okay? And we had this push and shove environment where we had a section of employees that were very content with what was going on. We had another section over on this side of employees that were not happy. And Squaw Valley is a union operation, and we've had very good luck with union and negotiating with union. And I, for one, had no problem of whether or not this agency would be represented by the union or not. I felt that it was up to the employees to be able to make that choice. And very early on in our controversy, I know John was here and Lane was here, I made the point, being from a union district, that let's have an election. Let's put a ballot box right here in this room, and let's let every employee come in, sign in as an employee, vote in an untraceable manner to be, I want to be unionized, I want to be represented, or I don't. And I felt that this was going to be an easy way to solve a very uncomfortable situation for the agency. And council, if you remember, Rod Richards said that we can't do this.
You cannot.
I want to know, Joe, why, and you might have touched on it in this presentation, why would it be unlawful for this agency, being specific here to our problem, and this is why we're all here, why could we not allow the employees to choose their destiny?
because the law changed and the statute now is specific in saying the employer can't require an election. And I wish, I will tell you, as I've grown older, it feels to me like it was about 6 weeks ago that the law changed, but I think it was probably 6 or 7 years ago that it changed. And our legislators in Sacramento, in their infinite wisdom, decided that's unfair. They decided to require an election, that they ought to just be able to do it with cards. And so the statute prohibits it. And so that's the quick answer to it is by statute, as the employer, you can't require it. I wish I wish it were the other way. It was the other way for 40 years, but the legislature changed it, and that's just the way the law reads now.
So basically, and I want to go back to one of the questions I asked you earlier, and that was an oversight committee on these cards. And we had this situation right here in this room where an employee had signed this card unknowingly and not informed about the issues that were moving forward, and he said, hey, right here in this room, I don't want to be a part of this. But yet he
I'm
is-
actually, Director Cox, I'm going to stop you because you're getting too close
I
into
see.
the actual case that we have.
Okay.
And I don't
Yeah.
want to
Okay.
offer
I
any
understand.
legal opinion
Okay.
about that in open session with it. because
So
it's-
back to the basis of my question is there's no oversight committee, and there's no way of this board to be sure that there's no fraud being executed in the issuance of these cards.
That's correct.
Not
It's
a
not the
prerogative.
issuance of it, it's the signature of it, and it's just the legislature has said, you have no say.
You have a procedure, you have to follow that procedure.
Yeah, and
Yeah.
that's what Richard has been saying all along, and like I say, my experience with the process has been not an uncomfortable situation, and all of a sudden we're getting into a little controversy here, and I felt that it could have been solved very easily, and that's totally not the case.
Joe, I want to just say, this, your presentation's been excellent, and for what was covered in here, it's been very informative to us as board members as we go forward in this process. And, did you have one other finishing? Make it quick.
The first thing that the employees would do typically would be to see if the agency has rules, define the bargaining units, so that when they do the cards, they know which cluster of employees
Yes.
belong to the bargaining unit, because it's a bargaining unit by bargaining unit
Right, that's correct.
basis. Okay.
That's correct.
All right.
Yeah, so your professional unit may have 8 people in it, so it would be 5
Right.
in that.
You wouldn't just, as a union, circulate cards to all employees and then figure it out later which ones belong to which bargaining unit.
Typically not,
Yeah.
but there's nothing that prohibits them from doing that.
Right, but it would have to be sorted out then
Yeah,
later.
later,
so
which is what it is.
Okay. Any other questions?
This has been
Thank you,
very,
Joe.
very
Yeah.
educational.
Great.
Yeah.
Thank you, Joe.
Great seeing you again.